Hello, my name is Irene Rekviashvili with Journey's End Refugee Services. Today we'll be talking about language access and the law, and more specifically, Title VI of the U.S. Civil Rights Act of 1964. Title VI prohibits a recipient of funds from the U.S. Department of Health and Human Services from engaging in policies or practices that have the effect of discriminating against individuals on the basis of national origin. So what that means is that if you receive funds from HHS, you cannot discriminate against people just because of their national origin when providing your services. This applies to individuals who have limited English proficiency. So individuals who do not speak English well, or who may not speak English at all. So what are organizations required to provide who are funded by HHS and who need to make sure that they don't discriminate based on national origin? Well, we have some guidance by the Office of Civil Rights. So first, availability of free interpreting services has to be present, either on the phone or in-person interpreter who can interpret for the patient. The interpreter has to be competent in medical terminology, and also vital documents have to be translated, and these translations have to be provided for the limited English proficiency or no English proficiency individual. And usually, if a language group constitutes 5% or 1,000 persons, whichever is less, of the population served, that's when the vital documents have to be translated and provided to the individuals. In some cases, if the language group is very, very small, oral interpretations of the documents may be provided. Some examples of vital written materials that should have a translation available are consent and complaint forms, or information about free language assistance programs or services. That information should be translated. Intake forms that have the potential for important consequences, and notices of eligibility criteria, rights, denial, loss, or decreases in benefits. So all these documents, the Office of Civil Rights recommends that any organization funded by HHS should provide these in order to not discriminate against individuals based on their national origin. Some examples of non-vital written materials that don't necessarily have to have a translation are menus, third-party documents, forms, or pamphlets distributed by a recipient as a public service, and large documents such as enrollment handbooks, although vital information in these handbooks may need to be translated. What institutions are covered by these laws? So any entity receiving direct or indirect federal financial assistance from HHS through a grant, a contract, or even a subcontract are covered by these policies. And some examples include hospitals, nursing homes, physicians and other providers' offices, home health agencies, managed care organizations, state, county, and local health agencies, state Medicaid agencies, and universities and other entities with health or social service research programs. The takeaway from this presentation is that language access is the law. It's the law that all HHS-funded organizations provide interpreting and translation services for their patients. Otherwise, it could be seen as discrimination based on national origin, which is against the law for HHS-funded organizations. Knowing the law will allow you to advocate for your patients and allow you to legitimately raise interpretation and translation issues within your organization if you find that your patients or patients of the organization are not receiving access to language services. Thank you.